Hi everyone, I'm attorney Minhas, and I practice U.S. immigration law all over the United States. Today's topic is going to be about the Violence Against Women's Act, which is filing the petition before USCIS, and also I would like to cover, just in case if you are in removal proceedings or in deportation proceedings, and you've probably heard about something called the special rule for cancellation or removal for battered spouses if your spouse is a green card holder or U.S. citizen or was a green card holder or U.S. citizen. Today's topic primarily focuses on this, especially because there are a lot of people who may not qualify for Violence Against Women's Act because they got a divorce and they no longer have the chance to file the petition because there is a rule that says that you have to file within the 2-year period after you get the divorce. Otherwise, you're not going to be eligible for it. So this video covers that. And the latest trend right now is everyone's reporting, and of course, this has happened to quite a few of my clients, where USCIS is not really interviewing these applicants. And they're just issuing a straight green card even after the I-360 is approved. And it's time for them to adjust their status. So I do want to mention, I will help those who are like, wait a second, I have my adjustment of status interview coming up. What do I do? What type of questions is USCIS going to ask me since I couldn't get my interview waived? So stay tuned. We're covering 3 topics, and I hope this is going to be helpful. So let's just dive into the first part. We're going to talk about the latest trends and the latest update where individuals or applicants, I can call them, are reporting that they are not getting interviews and they're just getting a straight green card after they received an I-360 approval based on their VAWA application. I do want to mention that VAWA applications are taking a very long time to be adjudicated, only mainly because there are just so much applications pending with USCIS and there is a huge backlog. So that's first and foremost. The next thing I want to mention is if, let's just say, you have not been waived for an interview and you are waiting to see, oh my God, what type of questions is USCIS going to ask me at my adjustment of status? Well, let's just dive into that and talk about it. USCIS will need to look into whether your marriage was actually real, whether it was bona fide in nature, and whether you entered into this marriage based on good faith. They want to make sure that you didn't enter into this marriage all to just get a green card. So that's the primary focus. There are times where the officer might get into details about the abuse, but technically they're not supposed to be covering that because you already had an approval for your I-360. So this is just based on whether you are going to be adjustable in the United States. I do also want to mention that some people are also scared to file these type of petitions because they're like, well, I crossed the border, so I don't have any entry proof. You may still be eligible to file for a VAWA because it really doesn't matter if that's the case. You have to have a very legitimate case, have it evaluated with an immigration attorney to see if you qualify for it, and you may be able to adjust even if you did cross the border or you don't have any entry proof. The next thing I do want to mention is USCIS may also ask you questions about whether you have a criminal background. If something pops up that you've been arrested in the past, they want to see whether that criminality is going to be a huge issue to see whether you're even eligible to get that green card. Couple of other things would be, yes, of course, they want to know the manner of your entry, any exits. They also want to make sure you're not lying. Credibility is a huge thing. They don't want you to lie about anything that's happened in the past. And if something comes up with a misrepresentation, then you might have to file a waiver. And of course, now the case becomes complicated. So do review your adjustment of status application that you filed. Go over the security questions. The security questions are really, really important. And if you don't understand anything, or you're planning on to go into the interview without a lawyer, then it would be wise for you to contact the lawyer to at least set up like a mock interview to see what type of questions may come up. You do want to do this ahead of time because you don't want to wait until the last minute. You have a bunch of nerves kicking in and you're going to be nervous at the interview, guaranteed. So you just want to make sure you're prepared. So again, if you're not planning on to take a attorney with you to the interview, you do want to make sure you get in contact with one if you're nervous about anything that you've probably missed out on, or anything that may have happened after you filed your petition and got approved. So if there's any changes, that is something that you should sit down and discuss with an immigration attorney. So those are the type of questions they may ask, focusing on credibility, focusing on any type of relief that you've filed in the past, and they just want to dive into that. They want to make sure that you don't have any criminal issues. They want to know about your entries and exits. They want to make sure you haven't used any other type of names. So those are things that they may cover. Now let's focus on the Violence Against Women's Act filed with USCIS. So as I previously mentioned, I said that there are times where people don't know. They've been abused mentally or physically or both, and they've gotten a divorce from their U.S. citizen or green card holder spouse, and then they find out later on that it's too late to be eligible to file for VAWA. So if you end up in removal proceedings and you think you might qualify for special rule cancellation or removal under VAWA, then for that type of case, you may not even have to worry about the divorce factor. You might still qualify to file for that relief if you are in removal proceedings. Okay, let me not get into the removal proceedings part as of yet. Let's go back and refocus on the USCIS part. If you file your VAWA and everything goes well, there's no numerical cap. You are able to adjust your status and get a green card here in the United States if everything looks good and you qualify. You do need to show that you are a person of good moral character. This is something that you can gather if you are volunteering at a church, or you have a great relationship with your employer and they can attest to the type of work you do and how you are doing at work, how are you as a person, or anybody in the community. So this is something that's very important. You want to show that you are a person of good moral character. Another thing with USCIS and filing for the Violence Against Women's Act is you don't want to have, negative factors. Like, what if you have a disqualifying criminal matter? Then you may not be eligible to adjust your status to get a green card for this type of process. There are other things that get filed with the VAWA petitions. And of course, I do want to mention that once you get your I-360 approved, then you may be eligible to file for a work permit. So there is a work permit once you get approved. And a lot of times you have to see whether you can file your adjustment of status concurrently along with your VAWA application. Now, the VAWA application itself does not have a filing fee, but for the adjustment of status, you do have to cover the USCIS fees. So that's an important part you need to know. You don't have to really show much of like a physical continuous residence. That's not really a requirement. But there are other things that you do need to show to prove whether you've been a victim of mental or physical abuse by your U.S. citizen or green card holder spouse. And now we are at the final topic. But before I jump into the final topic, I do want to mention that I have an informational video on the Violence Against Women's Act. Please go check it out. I did put the link in the description. I hope that's helpful to you and today's video as well. So let's jump into the removal proceedings, aka deportation proceedings, and whether you qualify for something called the special rule cancellation or removal case. And what is it? Who can file for it? Do you qualify? Let's cover that now. So I do want to mention that if you do qualify for the special rule cancellation or removal case, you can show, and you have to show, not can, but you have to show hardship to either yourself or your child who's a green card holder or U.S. citizen, or your parent who is a green card holder or US citizen. So hardship, extreme hardship is a requirement to show for this type of relief. There is a numerical cap. It's approximately 4,000 visas available. So it all depends. If you get approved for this type of relief, you will need to wait until the visa is available in order for you to ultimately get the green card if you do win this case before the court. Now, that is something that I do want to mention, that you will have to sit down with an immigration attorney to discuss and plan and see how long until you get a physical green card. And the most important thing is, if you are in removal proceedings or deportation proceedings, you do want to make sure you have an immigration attorney who can litigate and handle this type of case for you and make sure that the requirements are met and you have the evidence to back it up. Now, of course, you do need to also provide evidence of your abuser's status, whether they are a US citizen or a green card holder. You do also want to provide evidence of the abuse if you've been mentally or physically abused. Now, some people also panic and say, oh, I don't have a police report. That's okay. If you don't have a police report, there are other types of evidence that can be presented to the court in order to show that you have been physically or mentally abused. You do get a work permit through this type of relief if the application is filed, and you have to show good moral character for this as well. So I know I mentioned at the USCIS level for the Violence Against Women's Act, you need to show good moral character. You also need to show good moral character for this type of relief. It's an important factor. You don't want to have some type of disqualifying crime, which is going to take away and show that you're not even eligible for this type of relief. So if you do have criminal matters, this is something that you need to show to your immigration attorney and discuss over to see if you're even eligible to file this type of application before the court. And there is a continuous physical residence requirement, which is 3 years versus the 10 years that you need to show for a non-legal permanent resident cancellation and removal case. I know a lot of people talk about the 10-year rule. So for the cancellation and removal under the special rule, Violence Against Women's Act, is 3 years. So that is something you do need to show, that you've been here continuously residing. And of course, I'm not going to go over when that needs to be shown, what's the period that you need to prove that. That's more discussed in a private setting with a lawyer during a consultation. So I do want to tell you that there are a lot of things that people are not aware of, and if you qualify for both, you're qualifying for a Violence Against Women's Act, the petition, and then it ultimately adjusts for a green card, and you also qualify for the special rule, cancellation or removal, you can file for both. That's not a limitation. You may be eligible to file for both. It doesn't mean that you qualify for one over the other. That's one of the things I do like about immigration. You can file more than one petition and see which one you might be able to succeed on. Believe it or not, that's a possibility. But of course, I do want to mention, you want to make sure that you are eligible to file for each one of those applications. I do not want you to go ahead and start filing applications because you're like, oh, this is a VAWA, and then I was mentally abused, so I can just file this. No, don't go ahead and file it until you know for sure whether you're eligible. So again, I do want to mention that this video is informational. It's general in nature. If you have a case that you're very concerned about, I do recommend you setting up a consultation with our firm. But if you have general questions, I don't mind answering them, and you can drop them in the comment section below. But if it's private in nature, I don't encourage you to use the comment section. Again, I hope today's video was helpful. Please do share this with your friends and family. You never know who this might help. Like, subscribe, and hit the bell icon to stay updated. Again, this is Minhas signing off, saying check me out soon. I'll be back with another video.